Lawyers and Conveyancers Amendment Bill, first reading.
Mr Speaker.
Honourable Nathan Guy.
Mr Speaker, I move that the Lawyers and Conveyancers Amendment Bill be now read a first time. I intend to move that the bill be considered by the Justice and Electoral Committee. This bill amends the Lawyers and Conveyancers Act of 2006. The amendment reformed the regulation of the legal profession in New Zealand. It replaced the existing regulatory framework for lawyers with a co-regulatory regime that also covers the new profession of conveyancers created by the Act. This Act enables both professions to respond more effectively to the changing needs of consumers in the legal services market. The Act came into force on the 1st of August 2008, has been working well since its implementation. However, this bill makes an important change to the Act by restoring the title of Queen's Counsel to the office currently known as Senior Counsel and some auxiliary changes to eligibility for that office. The bill also makes some minor amendments to enhance the functioning of the Act. Can I talk first of all about Part 1 of the bill as it restores the title of Queen's Counsel to the office currently known as Senior Counsel. The Lawyers and Conveyancers Act replaced the title of Queen's Counsel with that of Senior Counsel. The Act also made a number of changes to expand eligibility for the rank, which now extends to lawyers in all forms of practice, including law firms. The bill will repeal this arrangement by reinstating the title of Queen's Counsel and restricting eligibility in most cases to barristers sole rather than lawyers in partnerships or firms. Mr Speaker, the title of Queen's Counsel reflects the public purpose and status of this position. It underscores the historical link between Queen's Counsel and the Crown and that has been established on the reputation in New Zealand and abroad. The rank identifies leading advocates in New Zealand and provides official recognition of excellence. In particular, it provides leadership to the legal profession and assists people to resolve disputes by identifying legal counsel. Eligibility for appointment of Queen's Counsel will be limited to barristers sole in most cases. This returns the rank back to its original form and recognises and protects the independence of Queen's Counsel, enhancing their ability to accept instructions and to provide frank, independent and objective legal advice. To maintain that independence, Queen's Counsel, who are providing regulated legal services as defined by the Lawyers and Conveyancers Act, will continue to practice as barristers sole, or they will be deemed to have surrendered the title. It is intended that the amendments will preserve the existing arrangements for those Queen's Counsel and Senior Counsel who have entered with other lawyers in partnership or incorporated law firms since the Lawyers and Conveyancers Act came into force. Clause 6 of the bill, containing new sections 118A and 118B, may require minor amendments to ensure that those purposes are accurately reflected. However, the amendments also preserve the Governor-General's power to appoint from time to time other lawyers, including litigators and law firms, as Queen's Counsel, in recognition of their extraordinary contributions to the field of law. This is consistent with the established practice of occasionally appointing exceptional lawyers in government and parliamentary council as Queen's Counsel, although they are not members of the independent bar. Mr Speaker, Part 2 of the bill makes minor technical amendments to the Act. First, the bill amends the definition of relative to include a reference to a grandchild of a lawyer or conveyancer practitioner. This will enable grandchildren to be a shareholder of an incorporated law firm or incorporated conveyancing firm, or if a minor, the beneficiary of a qualifying trust. Secondly, the bill permits a qualifying trust to be a non-voting shareholder in an incorporated law firm or incorporated conveyancing firm. A qualifying trust means a trust in which each beneficiary is a relative of one or more of the trustees, and each trustee for an incorporated conveyancing firm, a conveyancing practitioner, or for an incorporated law firm, a lawyer who is actively involved in the practice. The Act is quite specific as to who may be a shareholder of an incorporated law firm or conveyancing firm. This ensures lawyer or conveyancer control of an incorporated firm, which is important to maintain professional standards. The use of a qualifying trust as a vehicle for shareholding avoids the need for proliferation of relatives holding shares in their own right. It will also enable children and grandchildren who are minors to benefit from income through distributions from the trust. Thirdly, Mr. Speaker, the bill extends the power of attorney that those in sole practice must give to authorise another to have the power to conduct the practice to any periods where the sole practitioner is an undischarged bankrupt. The Act requires a sole practitioner to issue a power of attorney which enables the power to conduct the practice in a range of circumstances. These do not include the bankruptcy of a sole practitioner. Instead, when the practitioner is an undischarged bankrupt, a process needs to be instigated either by the New Zealand Law Society or the New Zealand Society of Conveyancers with the New Zealand Lawyers and Conveyancers Disciplinary Tribunal to have the practitioner struck off or suspended before the power of attorney provisions can apply and the practice can be continued. The amendment will remove the need for the cumbersome process and provide a more simplified and streamlined process in these difficult circumstances. This will also serve clients better, as it will be an immediate response to the situation and enable client matters to be managed more effectively. Finally, the bill makes a technical amendment to the complaints procedure. One of the reforms introduced by the Lawyers and Conveyancers Act is a new three-tiered complaints and disciplinary process. Complaints are usually heard in the first instance by locally run standards committees. Decisions or actions of that committee can then be reviewed by the Legal Complaints Review Officer. The bill amends the notice period for lodging a review with the Legal Complaints Review Officer of a standard committee decision. It provides that an application for review must be lodged within a 30-day period, which begins to run when the applicant is notified of the committee's decision. The date of notification is presumed to have occurred 5 days after the committee's decision. This amendment will ensure sufficient time for applicants to lodge a review application if they do wish to do so. Mr. Speaker, I commend this bill to the House.
The question is that the motion be agreed to.
Mr. Speaker.
Charles.